Hello everyone, welcome to Jurisage Academy. This is the founder of Jurisage. This is the next part of January recent events 2020. I hope you have checked the first part and where we have discussed about the three judgments, very important judgments. The link of that particular video is given below in the description. You can go and check it out. And then in this part, we're going to talk about another two major important judgments and side by side another some not so important judgments and some subjective part or subjective essay topics. So let's start the video. Let's talk about the fourth judgment of the January month 2020. Okay, so the fourth judgment is important regarding the anti-defection laws. So what is the judgment name? The Kesaram Megachandra Singh. This is Honorable Speaker. Now this judgment is related to the Manipur Legislative Assembly election. Now in 2017 11th Manipur Legislative Assembly election के बारे में ये केस हुआ था. क्यों हुआ था कि when the election happened, there was 60 seats in Manipur Legislative Assembly election, and after the result, Congress won around 28 seats, और BJP को मिला था 21 seats. So no party got the majority basically. But after the election result, some of the Congress MLAs joined the BJP to form the government. Now among those Congress MLAs, एक alleged MLA के against में disqualification application submit किया गया speaker के पास. Now problem has arisen after that. Now after considerable period of time, speaker didn't entertain that disqualification submission. कुछ respond नहीं दिया. Then that's why the appellant approached the High Court and then the Supreme Court. The main contention was that under the 10th schedule, there was no demarcation of time under which speaker has to entertain the application submission. The speaker might take 5 years for the next legislative assembly election तक वो decide नहीं भी कर सकता था. So the time limit is too huge. Okay, so that's why that is the contention कि इतना दिन तक तो टाइम नहीं लिया जा सकता है रिगार्डिंग डिस्क्वालिफिकेशन सबमिशन आप entertain करने के लिए. Now Supreme Court regarding this particular judgment, okay, while quoting the most important and landmark judgment regarding this anti-defection law, that is the Kyoto Holohan judgment, and another important judgment, that is Rajendra Kumar Rana, Supreme Court observed two things. One, under 10th schedule, speaker acts as the tribunal, and the second thing, speaker has to entertain the disqualification application within the reasonable period of time, and that is 3 months. Now these are the two notable observations under this particular case that you have to remember. Now side by side, Supreme Court also noted that speaker belongs to any political party, and that's why there might be biasness that may arise in the application process or in dealing with the application process of disqualification related to any particular member. That's why Supreme Court said there should be a separate independent tribunal that must entertain this kind of anti-defection laws. क्योंकि आप लोगों को पता है in recent time there are a lot of IRM GARM case चल रहा है, so that's why there should be an independent tribunal that will entertain this case, so the biasness will not occur in those scenarios. Okay, so this is the whole crux of the judgment. I hope you have understood. Now let's move on to another judgment. Next judgment is not very complicated in nature, but simple principles have been denoted by the Supreme Court. So what is the case name? Case name is Vidya Devi State of Himachal Pradesh. This case is basically related to the Article 300A of the Indian Constitution. Okay, now किसके facts क्या थे? किसके facts is very simple. Vidya Devi is basically old illiterate widow. She has her land. In 1967, that land was taken by the state without any due process. That land was taken forcibly. And आपको पता है 1967 और 1970s के टाइम में Article 31 was in place. So Article 31 के अंदर ऐसा एक रूल था, लॉ था, जिसमें स्टेट कैन टेक अवे योर लैंड फॉर द बेनिफिट ऑफ पब्लिक पर्पस. Okay, so that's why that land was taken, but there is no due process followed and it was taken forcibly, and also there is no compensation given to Vidya Devi. That is another important thing. Now you might be asking, ये 1967 का केस था and this case is being decided 2020. That's true, and the state taken that particular plea also कि अब 50 साल बाद तो ऐसे नहीं बोल सकते, because in between there are some petitions were filed by different people, जिसका भी स्टेट लैंड लिए थे in that time, but वो केस चलते चलते now this situation has came. Now in this particular regard Supreme Court said कि grievous injustice has been meted out to Vidya Devi, and now we have the time to rectify this injustice, and that's why we are going to entertain this case. Delay का बात ही नहीं आता है. Now second important thing, the state took the plea कि adverse position का, adverse position, you know, the state took the plea कि as it was 53 years after 1967, and we have the better title, and we have the title regarding that property because we are holding this property for the 53 years. Now Supreme Court told that you cannot take the adverse possession plea here. First of all, it's a totally different scenario altogether. You took the land forcibly, there is no compensation provided. It's not that Vidya Devi has no interest in the property. Vidya Devi has approached the court time and again. She has to, she has approached High Court, Lower Court, and then she came to the Supreme Court. So that's why adverse position वाला plea नहीं चलेगा यहाँ पर. Okay, so that's why Vidya Devi was given the compensation, 10 lakh compensation given by quoting the Article 300A. Basically Article 300A में क्या बोला जाता है? No person can forcibly dispossess a person for his private property without following due process of law. Okay, and that would be, if someone does that, that would be violative of his or her human right. So that is the law that has been provided while upholding the justice regarding the Vidya Devi. Okay, so these 5 judgments are very important. I have discussed 3 judgments before in that video. Now there are some other cases that you should definitely look into. Why? Because these cases are not that much of importance regarding the judgment in aspect, but important situations that have been mentioned here in this case. The first is all the 3 cases are Delhi gang rape cases. But why I have mentioned, because some or other issues have been came to surface regarding these cases. Okay, so first case is regarding the Vinay Sharma case. Is regarding the curative pleas that was dismissed by the Supreme Court. Now, Pawan Kumar Gupta, here the juvenility of the convict, that was dismissed, and you talk about the Akshay Kumar regarding that curative petition filed, and that was dismissed by the Supreme Court. And there is another case like Mukesh Kumar, if I remember, Mukesh Kumar case, जिसमें mercy petition was dismissed. Now, the curative petition, mercy petition, juvenility, each and everything are very important concept. You should definitely read about it because these things are quite going on for some time. Okay, so that's why I mentioned these 3 cases. Now, fourth case, Ruhi versus Anis Ahmad. It's regarding the 498A. It's basically, I'm not going to delve into this case. This case is not very much, I mean, legal development has happened in this case, but one simple important thing that has been laid down in this case, it's not that the wife doesn't need to be in the matrimonial home to file the cruelty or file the complaint under Article 498A. Wherever she resides, that particular court has the jurisdiction to entertain her complaint. As simple as that. Okay, so these 4-5 cases are important for you to understand. 498A and Delhi gang rape, different cases. Okay, so these are the cases are important for January recent judgments, and let's move on to the most important aspects also, that is the what are the subjective part topics that we are going to get from the January recent judgments. Okay, there are 4 I have mentioned. The first is right to access to internet. In the first part I have discussed about the Anuradha Bhasin judgment, and Anuradha Bhasin judgment has lot of it, right to access to internet. So please do give it a reading regarding right to access to internet, क्योंकि internet shutdowns were there in the recent news, and also whether we should entertain right to access to internet and as a fundamental right or not, and all those things that have been discussed with Anuradha Bhasin. So this is a very important concept right now to discuss, and you can write on this definitely by yourself. The second important topic is anti-defection law. There are a lot of Karnataka Assembly anti-defections, Madhya Pradesh anti-defections, a lot of anti-defections have been happened. So anti-defection is a very important concept regarding a subjective part. Mercy petitions, as you know, I talked about the Delhi gang rape. That thing is important. Curative petition, Delhi gang rape. So these four topics that we are getting from the January recent judgments. So these are overall January recent judgments that we are done with. Okay. And if you have any question, kindly comment below. We'll love to entertain that.
I hope you liked the video. Give it a thumbs up and don't forget to subscribe to our channel. And also don't forget to share this video to your fellow CLAT PG aspirants. And also, All India CLAT PG mock competition is going on. You can go and definitely participate in that mock competition. Download the Judicial Academy app. The link is given below in the description. Can you go and check it out? And for the recent judgments, video lectures, analysis, the course is available. Go to the link below. You can go and check it out. All India LLM Short Hype course. For any help, comment below. Thank you. See you soon.